Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. Welcome to this morning's webinar where we're going to be discussing the right to know law and payment issues, one of my favorite topics. Before we get started, I just want to go over a couple preliminaries. This session is being recorded, and if by chance you have a colleague or someone who couldn't make it this morning, the recordings get posted to the Office of Open Records website. Go over to the training tab, and it doesn't take too much effort. You can find the recordings. Usually a couple hours after the session, they get, I guess, put over to YouTube and then a link to YouTube from the website, et cetera, and you can access it freely there. Use it for future reference or any local training that you might want to do. Feel free to go ahead and use the recording as you deem necessary. Also, if you've never sat through one of these sessions before, it's essentially a PowerPoint presentation with me talking in the background. All of the PowerPoints that we use for these webinars, the different topics and so forth, are also posted on our website under the training tab. Again, if you have a colleague who couldn't attend today, or you're interested in conducting some future training, or maybe just for your own reference, if you'd like a copy of the PowerPoint, feel free to download it from the training page and have at it. You're welcome to it. As far as the way we run these things, if you have any questions while I'm talking, feel free to type them in the meeting chat feature, and I'll do my best to answer your questions as we're proceeding through the presentation. However, I have two things I have to ask of you. First is, the topic here is the right to know law and payment issues. So let's try and stay on topic and keep our questions limited to that. The other thing, which sometimes can be a little more difficult, is that it's really helpful to me if you can be as concise and brief as possible. Occasionally, folks will type in a couple paragraphs, and honestly, it's just awkward for me to sit here and read through that while everyone else is waiting patiently. Excuse me. So if you have, a situation that is just unique to your particular circumstances, or it's unusually complex, we're going to do one of two things. We'll wait until the end of the presentation, and I'll come back, and we can deal with it then for the good of everyone who's attending, or we'll take the conversation offline. There's contact information on the screen right now, the office phone number, as well as the URL for the website. On the website, there are email accounts where you can contact the office directly. When you do that, there's administrative staff who will kind of screen your messages. They'll either be able to answer it directly, or if it's something that would better be answered by one of the attorneys or the executive staff, they'll bump it up the ladder, and someone will get back to you, usually within 24 hours of you contacting us. Okay? So there's all the preliminaries out of the way. Let's dive into the session. Like I said, right to know law, payment issues. It's like I said at the beginning, it's one of my favorite topics because it's probably one of the least understood about the right to know law. There is this perception by many on both sides of the equation, on the agency side and on the requester side, that the right to know law is free. And it's not, okay? There are costs involved. And I think, especially on the agency side, it's helpful to know what you can charge for as well as what you can't charge for. Because again, a lot of misunderstandings. We get out there and we start looking at agency websites, and there's a lot of misconceptions. So hopefully we'll get you steered in the right direction, get all those misconceptions out of the way, and get you back on track here. Okay. Within the right to know law, section 1307, there is language in there that gives the Office of Open Records the authority to establish a fee schedule for the right to know law or open records law program. And when I use those two terms, they're interchangeable. They mean the same thing. Okay, so the fee schedule is established by the Office of Open Records. It's posted on the website. Again, that URL is part of the PowerPoint presentation. It's easy to find. And it's reviewed every 2 years. And I think, gosh, we might be due for that. I can't remember whether we did that last year or 2 years ago, but I think if we're not in the midst of it already, it's coming up soon to review the fee schedule. When we do that, we solicit comments through social media, our website, and other means where you can contact our office, let us know of any concerns that you may have with the fee schedule. We'll take those comments under advisement. And honestly, I can say from personal experience that we have changed the fee schedule in response to public comment. Okay, so once that occurs, then the fee schedule is finalized, it gets posted, and it's updated accordingly. Now, in a nutshell, what the fee schedule says is that agencies can charge for hard copy up to 25 cents a page, single-sided black and white for 8.5 by 11 or 8.5 by 14. If by chance someone is requesting color, then it's up to 50 cents a page, single-sided, 8.5 by 11, 8.5 by 14. Then all other hard copy printed documents are at the actual cost. And I'll talk about this a little bit as we get further into it. But when we say other sizes, meaning that if you have a copy machine or kind of a multi-use machine, and it doesn't print in the size that the original is or how it's been requested. If you can't generate a copy using your local device, then you would charge whatever it costs to produce it at the size it's being requested. Usually we're talking about blueprints here, okay? You don't have a large scale copier, so you got to run out and have a copy of the print made. You can charge whatever the agency is being charged. And I'll get into this in a little more detail here as we go through the presentation. Now, you see there's an asterisk up there, okay? This was changed last time that we adjusted the fee schedule. And that is that if someone has requested a large number of records, hard copy, and it exceeds 1,000 pages, once you get above 1,000 pages, the maximum cost drops to 20 cents a page. Okay, and it's simply economies of scale taking place here. And then you see down at the bottom there, read the footnotes. Okay, I can't emphasize this enough. You go to the fee schedule and there's like a dozen points, okay, that clarify, what costs what. But then at the bottom of the page in fine print are all the footnotes, and the footnotes are where the meat of the fee schedule really is. Okay, there's always exceptions. There's always exceptions to the exceptions. The footnotes are where you're going to find out what those are, and it will help you immensely in working your way through what you can charge for, what you can't charge for. Usually those footnotes will refer to case law where, an unusual set of circumstances, an agency applied the fee schedule, but because of those unusual circumstances, there was some exception or someone took exception. It ended up in court. The courts ruled in a particular way. So this then is how you would apply the fee schedule under this specific set of circumstances. Okay, it will help you out to know those little nuances where the courts have provided clarification as to how the fee schedule is applied with the specific set of circumstances. Okay, so folks, read the footnotes to get a full understanding of the fee schedule. And I would say that for any law that you're trying to understand, always look at the definitions, always look at the footnotes, because if there's If there's some nuance with the language that might be unclear, or if you think there's conflicting language, that can usually get you steered in the right direction and provide clarity. Okay. So I mentioned pass-through costs, and I kind of alluded to that with the blueprint example, but a pass-through cost is an actual cost that can be documented, that it costs the agency X number of dollars to produce this record for the requester. Thus, we can pass that cost on to the requester. Blueprint is a good example. You don't have a large-scale copier. The blueprint is, in fact, a public record, given what's on the print. So we have to run down to Kinko's or Staples or maybe the local engineering shop. They make the copy for us, and let's say it costs $10 a sheet. Okay, so they bill the agency $10 a sheet. We can now pass that cost on to the requester because, one, we couldn't do it in-house. Two, we have an actual receipt that we can show this is what it cost us. Now, I need to clarify this a little bit. There's always an exception, and I want to let you know that there was a court decision last year that has kind of clouded this particular issue with pass-through costs, and the court honed in on some very specific language that said, look, the agency bears the burden of the cost of a response in certain circumstances. Like I said, the decision has kind of created this gray area. Whether or not the courts continue to proceed in that direction, I can't say, because we haven't had any further decisions, and I'm not aware of any cases currently in the pipeline dealing with this specific one. But I just think it's important for you to know that what I just told you, prior to a year ago, I would have said it's black and white. Since getting this decision a year ago, I just want to caution you that it may not be the case if it would be subject to appeal. Okay, but for the most part, I would recommend go ahead and proceed with the concept of pass-through costs or outside costs that can then be passed on to the requester under most circumstances. We haven't encountered it for years, and I probably should update this slide, but there was another one where we talked about analog recordings, cassettes and microcassettes is basically what it is. And many agencies will record their public meetings. Some of them still use analog recordings. So how do you make a copy of that? Okay, because those double cassette decks no longer exist. And honestly, most agencies are using digital means for recording their meetings now. I mean, you can do it on a smartphone or you can do it on a laptop. Okay, but still there are some who are using cassettes. So what you have to do is usually go find a local audio store or a recording studio, and they can make the cassette for you, but they're going to charge you for the cassette and they're going to charge you for the labor that it costs. Okay. I'm not aware of this happening for years. And like I said, I probably should update this slide, but it used to be a good example of a pass-through cost. And then finally, storage media like flash drives. Let's say someone requests a large amount of electronic copies. They cannot be emailed, usually because of the size of the files. So we're going to put them on a flash drive. Okay, and I'm going to talk about flash drives in a second here. Again, because that's another one where just given changes in technology, we're not seeing as much transfer of files by flash drives anymore. Nevertheless, if someone requests a large number of electronic files, you have to put them on a flash drive and mail them out or, hand deliver them or whatever. You can charge for the flash drive if you can show a receipt for what that flash drive cost you. Okay, question has popped up. Could the OR update a fillable form to include costs? Can we accept anonymous requests or with minimal info? Okay. Let me think here. Okay, a fillable form to include costs. No, we won't do that, Ginny, mainly because how costs are oftentimes dependent on specific circumstances. Okay, for instance, while we have a fee schedule, that fee schedule says up to 25 cents a page. And there are many agencies that do not charge the maximum. The OOR is a good example. In many cases, we waive the fees. So having a fillable form, while I could see how that would help you out, it just wouldn't apply to every agency. Now, if you want to do that on a local level, maybe you've got some IT experts there who can do that for you. But having one for statewide application, it just wouldn't work out because of the variance. One of the nice things, well, I consider a nice thing about the right to know law is that it affords the agencies a great deal of flexibility with how you administer your open records program. That includes costs. So to come up with a generic form that would have all the costs on it, I just don't think that would work out. Okay, and then this doesn't really relate to cost, but you're asking about anonymous requests. I'd suggest sitting in on the basics course, but yes, you can accept anonymous requests. Okay, and an email address is considered an address under case law related to the right to know law. Okay, so back on topic here. Let's talk about flash drives. Sidebar here. This is not included as part of the right to know law, but it is included. We put it in here as a best practice. It was brought to our attention by a number of municipalities that do this. We think it's a good idea. You don't have to do it, but maybe you want to think about it. And it comes to using flash drives. Used to be someone would request, a bunch of electronic records too big to email because of size limitations for attachments on our email system. So you put them on a flash drive and send them out, and you charge for the flash drive. Okay. Very labor intensive. Number one, you might have security issues related to the flash drives. Number two, you got to go out and buy a bunch of flash drives to have on hand. Number three, you got to go through an invoicing process to charge for the flash drives. It just got to be too much. So what agencies have done, they're saying, look, if we've got a large number of files, you send us the flash drive and make sure it's unopened, brand new. That way, there's a reasonably good chance there's not going to be any malware on there or any bad files that might infect our network. Then what we'll do at the agency is we'll transfer all of your files over to a laptop. We'll unhook the laptop from our network. Then we'll plug in your flash drive, and if there is any bad stuff on your flash drive, the laptop virus software will pick it up. But if not, we'll transfer the files over to the flash drive. Then we'll mail it back to you in the self-addressed stamped envelope that you included with your flash drive. And that way, there's no invoicing needs to take place because you gave us your flash drive. There's no fear of a virus because it was new and unopened, and we took the appropriate steps to make sure that doesn't happen, et cetera, et cetera. Okay, I need to emphasize once more, this is not in the law. It's just that we view it as a best practice if you're dealing with flash drives. It's what we do here at the Office of Open Records, but we didn't invent this. This, was brought to our attention by a number of municipalities. Okay, let's move on. Let's talk about what you cannot charge for, because like I said, we routinely review agency websites to make sure that they're in compliance with Right to Know, and it is surprising, some of the stuff that we still run across. For instance, the Right to Know law is very specific. You cannot charge for your labor. Okay, it's just considered the cost of government doing business in administering the Right to Know law. You can't charge an hourly rate or any sort of fixed fee. You cannot charge for legal review, whether it's your in-house counsel or you have an outside solicitor. Okay, again, it's just considered the cost of doing business. We've seen some agencies attempt to attach a processing fee. Okay, you submit a right to know request, the response is going to cost you $25. No, you cannot do that. Okay, no set fees. We found some where they say, okay, we'll provide you with a response, and if we have to redact any sensitive information, that's going to cost you an extra $10. You cannot do that. That is not permitted under the right to know law. We don't see it as much as we used to, but agencies used to attempt to charge a scanning fee. And their logic was, okay, if we can charge for a copy, to generate an electronic scan, it's the same exercise. You know, we're creating the same wear and tear on our device. It's the same labor that we would go through to generate a copy. So why can't we charge a scanning fee? Well, it's because you cannot charge for electronic records. Okay, and scanning is generating an electronic record. Now, we're going to get into this here in a little bit, but I would ask, do you need to generate the scan at all to comply with the right to know law? Because there is a very good chance that you do not. So when someone contacts us, why can't we generate or why can't we charge a scanning fee? My first question is, should you be scanning at all? Because under the right to know law, you probably don't have to. All right, and then electricity, I only put this in here for the good of the order. No, you cannot charge for the electricity to generate a copy. And yes, the question has come up. And my first question back to them is, how are you going to figure out what to charge? Okay, so no, electricity is off the table. And then, like I said, you cannot charge for electronic records, which would be emails, Word documents, Excel spreadsheets, and various database files. Now, if there is a dispute over the fees, meaning if the agency is attempting to charge for a response and the requester takes exception to that, the requester can claim that it is a denial and they can file an appeal based on their taking exception to the fees that the agency is attempting to charge. And if you go to our website and go to the Final Determinations database, the search tool, you can go to the field where you can just put in a random text string, type in fees, and all of the final determinations that deal with fee disputes will come up. And you can see some of the issues that have been argued, like redactions and electronic records and so forth, what you can and cannot charge for. It's going to take some time to read through these decisions, but it can be interesting, especially the ones that have been appealed up to like the Pennsylvania Commonwealth Court, Pennsylvania Supreme Court, where they provided clarifying language on what you can and cannot charge for. Kind of interesting reading if you have some spare time. Not the most exciting reading, admittedly, but if you really want to understand how this whole payment issues thing works with the right to know law, that is a good place to start. Okay, so that's what you can't charge for. All right, I mentioned the scanning fees. This is a very interesting aspect to the right to know law, and it is probably one of the most useful bits of information you're going to get out of this morning's presentation. You go to section 701 of the law, and I'm going to paraphrase here, but it basically says that you only need to provide the records, the responsive records, in the medium in which they exist. Okay, that's my paraphrasing. Now let me translate it to English. It's basically hard copy versus electronic. So let me walk you through a scenario here where hopefully it will illustrate what this means. Let's say we're a municipality that processes building permits. Now, our building permit application process is all hard copy driven, meaning someone submits an application for a building permit. They have to fill out forms, they have to provide supporting documentation, plans, and the like, okay? And it's all on paper. Now, that comes in, it goes to our codes department. All of the correspondence back and forth is paper driven so that they have, hard copy records, et cetera, et cetera. Ultimately, we issue a building permit, and that is a piece of paper that goes out to the applicant, all right? All of this hard copy then gets put in a file folder and put in a file cabinet within our codes enforcement department. All right, so someone submits a right to know request and they send it by email and they say, I would like a copy of the building permit file for, XYZ North 3rd Street. And I want it sent to me electronically. And they do that for two reasons. Number one, because it's easy. Number two, because there's no cost for electronic files under the right to know law. Okay, but then you come back to this language in Section 701, and what it means is that if all of our records are hard copy and you're requesting, or the requester wants them in electronic medium, the agency does not have to scan these files in because that constitutes converting them from hard copy medium to electronic. And you do not have to do that based on this language in Section 701. So you see why I say or ask the first question there, why do you need to scan them in the first place? Because based on this Section 701 language, you probably don't have to. Now, a couple things here. First offhand, you can, if you want to, the agency at their discretion can scan the hard copy records in to make them electronic, but you cannot charge for electronic records, okay? No scanning fee. For instance, the Office of Open Records, we usually, well, first offhand, most of our records are electronic to begin with. But if we would have to scan in a hard copy record, we don't charge for them in most cases. And there's always an exception, but most cases we don't charge. So that explains Section 701 with the whole scanning issue and the difference between a hard copy record and an electronic record. Okay, so no scanning. Then we get into medium versus format, which is different. Okay, medium, it's hard copy versus electronic. Format is the nature of the electronic record and the software program that's used to access that record. And essentially, the issue is PDF versus Excel. And this is an evolving area of case law within the right to know law. It used to be that if someone requested a copy of an Excel spreadsheet, case law said that if the agency provides it in PDF, that is acceptable. Because if you're aware, if you provide an Excel spreadsheet, number one, it can be changed. And number two, the requester can look at the formulas upon which the cell results are based. And there was a concern, rather unfounded, but there was a concern that if we provide the Excel spreadsheet, the requester can then take that and make changes to it and misrepresent what we provided. Okay, now I'm not aware of that ever happening, but yet people on the agency side of the equation were concerned. So they said, well, what if we provide just a PDF, which essentially is a snapshot of the Excel spreadsheet without the formulas being present? Okay, this got litigated, and ultimately the court said, look, PDF is a copy, and under the right to know law, that's all you need to provide as a copy of the original. So PDF is acceptable. Now come forward 10 years, And where we're at now is a little more complicated. If someone simply requests a copy of the spreadsheet, you can provide PDF, and that's acceptable. But if someone specifically says, I want a copy of the Excel spreadsheet, then that is what you provide with the formulas and all. Okay, that's the distinction. Now, you might say, like people used to say, well, that would allow them to change it. Okay, the thing is, that would be a legal issue outside of the right to know law. If they are taking the copy you provided, changing it, and misrepresenting it in some way, that could be a legal issue, but it's not a right to know law legal issue. Number two is that we follow these things, okay? We monitor right to know law issues through various news feeds and case law indexes and so forth. And in the 12 years that the right to know law has been in force, I'm not aware of this ever occurring. Okay, so it is somewhat of an unfounded fear. You don't really have to worry about providing an Excel spreadsheet in response to a right to know law request. Okay, and then you get into, okay, can the Excel spreadsheet be sent password protected? Well, yeah, but how would the requester then gain access to it? Because you're providing the spreadsheet, but you're not giving them access to see what's on the spreadsheet. So then you say, okay, well, we'll provide the password, but it's a public record, so you're providing it in the first place. So, I don't really understand why you would do that. Okay, because it is a public record. You've determined that when you've decided it's a responsive record to the right to know request. So why would you bother? But you may have a valid reason for doing so. I just can't think of what that would be at this particular point. All right. And then we get into proprietary formats. This doesn't happen that often, but for instance, police departments, many of them will contract for proprietary software for their record keeping. And the only way you can get a record generated from that is readable would be if you had a copy of the proprietary software yourself. The appropriate response in that case is to deny the request because you cannot, or the police department cannot provide a copy of the report in a readable format, whether it be CSV, ASCII files, or whatever. Okay. Case law has supported that. Okay. And that if the agency is using something that they cannot generate a report in a readable format, then they legally can deny the request because of that proprietary software. And then another one that comes up, maybe once every 2 years or so is someone requesting from an agency that uses QuickBooks to do their financial. They want a backup copy of QuickBooks itself. QuickBooks is copyright protected. You would be violating that copyright by sending them a copy of QuickBooks so that they can read your QB files. Okay, I know it sounds kind of stupid, but you'd be surprised. It comes up every couple of years. Okay, moving on. Redaction costs. While you cannot charge a redaction fee, what do you do if someone's check payment bounces? Okay, I'm going to get to that, Dana. Okay, you're a couple slides ahead of me. Slow down here, but I promise you we will get to that issue. I'm going to have a cup of quick swig of coffee here. Okay, excuse me, but let's talk about redaction costs. Redaction is where you've decided it's a public record, you're going to provide it, but there's some sensitive piece of information on there. Like, let's say a social security number, okay? Social security numbers are not public. So there's a couple things you can do here. If you have redaction software, like let's say you have the Adobe Office suite, you can redact it electronically. And because everything remains electronic, it's secure, and there's no cost for that redaction exercise that you just did. But let's say you don't have Adobe and it is an electronic file. So the only way to redact it is to print it out, take out your Sharpie or your marker or whatever, black out the Social Security number, then you scan it back in, and you now have manually affected a redaction for an electronic record. In this exercise, if you're doing the manual redaction, you can now charge for the piece of paper that you had to generate to affect the manual redaction. Okay, you see how that worked there. Okay. And you can use this for a number of pieces of sensitive data, like Social Security numbers, home phone numbers, personal email addresses, and the like. Okay. But if you have the software, you should, and notice I'm saying should, not shall, you should use it, okay, because it's the cleanest way to do it and it's the most secure. The other thing that you need to be aware of, it's let's say someone has not requested copies, but they've requested to exercise the inspection provisions of the right to know law. So they come in to review the originals. And let's say the originals have a Social Security number on them. Okay, well, in that case, you would again generate a copy and manually black out the Social Security number. Okay, even though most inspections, there's no cost involved, because you had to redact something, you can now charge for that manual redaction that you had to do. You see how that would work. But two things I want to caution you with. Whenever you're doing a redaction that's going to result in a charge, notify the requester beforehand so that they're not taken by surprise. Okay, whenever there's a surprise, things tend to go south. So if you let them know before you actually incur the cost that there's going to be a charge, everyone will be on the same playing field and no surprises. It will go much smoother. Secondly, is that if you're dealing with an inspection and you're generating a copy and you're charging that person for the redaction, they should be able to leave that inspection session with the copy that you generated because they're paying for it. Okay. I mean, if you're charging them for that piece of paper, they own that piece of paper and they should be able to walk out the door with it. Okay. Makes sense? Yeah. Now, a redaction, in essence, is a denial. Okay, yes, you're giving them the record, but if you black out any portion of that record, you're denying them access to a piece of information. Legally, the agency is bound to say, number one, we're redacting. Number two, we're redacting because, and you would explain, because there is a Social Security number behind the redaction, or because the area that we've redacted applies to one of the exemptions within the right to know law. Okay, you have to make your legal case for any denial. Remember, the agency bears the legal burden, so you explain what is behind that redaction to the satisfaction of the requester. If the requester disagrees, because a redaction represents a denial, they can appeal that. And yes, we have dealt with extensively, as a matter of fact, denials based on redactions. Going back a couple years, the medical marijuana issue with the Pennsylvania Department of Health, in the applications that providers would provide or supply to the Department of Health, they were allowed to self-redact. And the courts decided, no, that's inappropriate based on the misuse of redactions during that exercise, okay? So the takeaway here is that redactions are denials, denials can be appealed. So you need to be careful with what you determine is you're going to redact. Okay, hopefully that's clearer than how I explained it. Okay, moving on here. Charging fees. Okay, this gets back to the question about bouncing checks. Okay. Listen closely here, because this is another commonly misunderstood aspect of the right to know law. All of the deadlines that are detailed in the right to know law, for the most part, apply to when the response is due, not when the records are due. Okay, so if you are granting a request, you've got the 5 business days, okay, 5 full business days. Okay, so you issue a grant. That grant says, we're going to provide you with the records. Along with that, your response can say, and we will provide you with the records when we receive payment and that payment clears. Okay, so Dana, that kind of touches on what you were asking here. Once your check has cleared the bank, then we will provide you with the records. And that can be beyond the 5 business day deadline. Or if you've taken an extension, that can be beyond the 30 calendar day extension deadline, where you're obligated to provide the final response, not the records, but the response. Okay, so the right to know law is silent on when you provide the records. I know it's somewhat subjective, but it's within a reasonable period of time once the check has cleared. Okay, now if the check bounces in this scenario, well, then you haven't received payment. And under the right to know law, really all it says is that the records are provided upon payment, which translate that to English, it means that the person pays first, then they get the records. So if the payment bounces and you haven't provided the records, well, then you just deny it based on non-payment. Or you let them, clear it up. Maybe they didn't realize that the account was overdrawn or whatever. And but in that particular scenario, from the agency's perspective, it's no harm, no foul, because you haven't provided the records yet. Okay, so legally, what I'm saying here is that you can wait for the check to clear before you provide the records. You just have to make sure that your response goes out within the appropriate deadlines in order to comply with the right to know law. Now, let me walk you through here a special set of circumstances where we're dealing with a particularly large response. And we kind of go through the same exercise that I just did here. But when you get the right to know request, when the agency gets the right to know request, they do a quick estimate here and they realize, well, this response is going to exceed $100 because of its size. It's a large response. In that particular instance, before you even begin processing the request or the response, you can go out to the requester and say, because of the size of the response, the estimated size, we're requiring you to submit a down payment first. And that's how I like to couch this. I think the right to know law, when they were writing it, they realized that they didn't want agencies to get stiff with preparing a large response and never receiving payment. So under this provision, Section 1307H, the agency has the discretion where they can demand kind of prepayment, this security deposit, okay, before they begin processing the large response. So they get the payment, they hold the check, then they begin processing, okay? And when the response is ready, okay, then you can either process the check or you can give it back, and you have an exact amount at this point. And it's really up to you. I mean, you can process the check ahead of time if you want to. Personally, I recommend just holding on to it and then working out the exact amount, whether it's a little high, a little low, when it comes time for the actual exchange of records. Okay, so then you process the payment, it clears the bank, and then you make arrangements for actually providing the records to the requester. And that can be, you know, hand delivered, mailed out, or whatever, okay? It's really, again, it's at the agency's discretion as to how they want to process payments, how you want to handle invoicing, and so forth. Because the right to know law does not specifically address most payment issues, that provides the agency with a great deal of flexibility on how you go about managing your open records program payment processes. And that would also apply to any non-payment issues. You know, how you deal with collections of non-payment really is up to you. Okay, moving forward. Which, when we talk about non-collections, this is an important facet. I'm not going to go into great detail on this particular scenario because, number one, we're running behind a little bit. Number two, we just don't encounter this a little bit, or we don't encounter it that much anymore. Let me get a sip of water here. Okay. If, like Dana was alluding to, there's non-payment. Let's say that you receive a right to know request, you grant it, and you just provide a response, and at the same time you provide an invoice. You say, okay, here's the records, they cost $5, send us your payment, and that payment never shows up. Or let's say, well, yeah, let's continue with that scenario. So the person owes you money. Then they turn around and submit a second right to know request. Because there is this outstanding fee, because they owe you money, you can deny the subsequent right to know request based on non-payment. If they have like an account that is in arrears, you can deny the subsequent right to know request based on non-payment of the previous right to know request. So let me go off script here a little bit. Most people who submit a right to know request are willing to pay a nominal fee for their public records that they're seeking. Okay, they've got a problem, they need records to solve that problem, they're willing to pay that 25 cents a page. However, there are some people, not a lot, but there are some people who misuse the right to know law. They've weaponized it. For whatever reason, the relationship between that person and the municipality has broken down. They've decided they're going to be a pain in the neck. One of the ways they're going to be a pain in the neck is to submit a lot of frivolous right to know requests. Okay, legitimate requesters are willing to pay a nominal fee. Frivolous requesters usually are not willing to pay to be a pain in the neck. So if they submit a right to know request, you provide a response with an invoice, and they never pay, you no longer have to respond to any further right to know requests from that person as long as there is an outstanding fee. Okay, that is how you deal with most problem requesters. All right, now let me go back on script. If there is an outstanding fee and you issue a denial, make sure all your I's are dotted and your T's are crossed, because it is a denial and thus it can be appealed. And again, if you go into our final determinations database, search on fields, search on fees, all these decisions are going to come up. And what the courts have said and what our appeals officers will do is they'll say, send me all the paperwork. And if all your I's are dotted, your T's are crossed, you can show the communications with the requester how you came up with the fees that you're charging for, et cetera, everything looks in order, the chances are very good that the appeals officer is going to agree with the agency, and they're going to say, yes, these fees are outstanding, they're appropriate, you no longer have to respond to the requester, to this requester, until they've settled up their account. Okay, now questions popped up. I have a right to know request for all documentation for 4 years of information on any communication for a lawsuit. How long do I have to accumulate that? Okay, Brenda, this really doesn't deal with payment issues, but I'll just answer it real quick. Okay, number one, if it's a legal issue, if it's a lawsuit and it's an active lawsuit, you should be talking to your solicitor, because there very well could be rules for discovery in a lawsuit, which are different than what the right to know law allows a requester to have. Okay, so talk to your solicitor, see whether or not the rules of discovery apply, because that will trump anything that's issued through the right to know law. Number two, you're talking about file retention. If you are a borough or a township, you want to take a look at the Pennsylvania Records Retention Schedule, which you can find on the Pennsylvania Historical Museum Commission, Bureau of Archives and History State Record Center website. Okay, again, this is all covered in the basics of the right to know law, because you're not really asking a payment issue question, but hopefully that'll get you started in the right direction. Number one, talk to your solicitor about anything related to a lawsuit. Okay. All right. So back to the slide here. That's how you would deal with someone who owes you money and denial of any further right to know requests. Okay, I've kind of alluded to this with reaching out to the requester, no surprises. And when you receive a right to know request on the agency side, do a quick estimate, okay? All right, the person's requesting this report, it's X number of pages. They're looking at this file. It looks to be, okay, another 50 pages. It's going to cost about $30 for us to generate a response. Before you begin making copies, pick up the phone, send an email, whatever, reach out to the requester and say, we estimate it's going to run about $30. Are you okay with that? Again, a legitimate requester is probably going to say, yeah, that's kind of what I was figuring. Go ahead and process it. In those instances where, let's say it's a problem requester, they're suddenly going to say, oh, no way, I'm not paying for that. Okay, so they're withdrawing their request. And that way, you don't have to begin processing, making all these copies, because you know that they're not going to pay for it. All right, so there's absolutely nothing within the right to know law that prevents communication between the agency and a requester. Okay, you can talk to each other, and I strongly recommend that you do that. All right, communication is good. Okay, and a requester can put on the form when they submit it that, look, if this is going to exceed $10, I want, or whatever amount, I want you to contact me first. Okay, that's completely acceptable to do that, and the agency should honor that. Okay, and if they don't, they can find themselves, on the opposite side of a final determination into who bears the costs for a response. Okay, and then I want to finish this slide with, an agency cannot, under the right to know law, an agency cannot demand that a requester tell them why they are filing a request. But that doesn't mean the agency can't ask. And sometimes the agency has the expertise to solve a requester's problem just by finding out why they need the records. Okay, and sometimes the request isn't clear. You need to look at this from the requester's perspective. They have a problem. They know that the agency has the record. They're just not sure which record it is. So their approach is to cast as wide a net as possible. And somewhere within that net, I'm going to find my record. Whereas the agency is looking at this from the exact opposite perspective. They want the request to be as narrow as possible because that's how they save themselves a lot of work. Kind of going back to Brenda's point about this 4-year lawsuit. Okay, well, if you know why the person is requesting the specific record or what specific record they're looking for, the agency is in a much better position to locate it and provide it. And that way, everybody's problem is solved. The requester gets the exact record that they're looking for. The agency only has to find one record and provide it as responsive to the request. The way that happens is through communication. Okay, so you attempt to build up this trust where everybody's on the same side. The agency picks up the phone and say, hey, I got your request. I'm not sure you realize how much work is involved here and how much this is going to cost you. Do you mind telling me why you're submitting this right to know request? The requester assumes trust here. They explain their problem. The agency says, oh, well, yeah, we've dealt with that before. I know exactly the record that you're looking for. I could have that ready for you this afternoon. Okay, everybody wins because people are talking to each other. All right, so communication is good. All right, moving forward. Changing speed here, certified copies or certified records. Section 1307C allows the requester to ask that the responsive records be certified. Maybe they have to submit them to court for whatever reason. Okay, so certification is the agency simply certifying that what we are providing you are true and correct copies of the originals. The agency is not certifying the provenance of the records themselves. They're not saying what's on the original is truthful and accurate. Okay, they're simply saying the copy is accurate. It is an accurate version of the original. And, you know, if you're dealing like with a law enforcement agency, you're not like, you're not saying anything similar to like a chain of evidence. Okay, that's not what you're certifying here. You're only saying that these are good copies. It's what we call self-authenticating. Okay, you're simply saying that we haven't altered the copy in any way. That's what you're certifying. And the right to know law and the fee schedule allows you to charge up to $5 per certification. If you're curious, if you get a request for certified records, you can find sample language in the Arrow Guidebook, which is, again, on our website, 78 pages. You download it for free. You go through there and you can find the sample language, along with a lot of other useful language that and processes that we've developed here at the Office of Open Records. Okay, and then we get into another section that comes up periodically. It deals with transcripts. Okay, it popped up. I looked on your website before this meeting and couldn't find it. Are you talking about the Arrow Guidebook? I think so. Look under forms. Okay, I think, you know, honestly, the website is constantly undergoing changes and revisions. It used to be under forms, okay? Check that out. If you cannot find it there, Teresa, send us an email and one of the admin staff will find it for you. And if it's not there, if it got removed from the website, let me know about it and I will take care of that because it should be there. Okay, transcripts. Usually this involves like a zoning hearing board or a code review or something like that. And they've held a hearing, okay? And a hearing is different than a public meeting, okay? A hearing is an adversarial setting where someone is, you know, you've got attorneys arguing before a board. You know, they're requesting a variance or you know, they're taking exception to a code violation or something like that. Okay, so you have this hearing. Under the right to know law, transcripts are public records, but there is a two-part test before they become public. and the fee schedule for the right to know law would apply. The first is that all appeals need to be exhausted in the adversarial process, meaning that the hearing board has issued its ruling, it's been appealed to your court of common pleas at the local level, that's been exhausted, or they chose not to appeal, and they did not go up through the state, Commonwealth Court, Supreme Court, or if they did, there have been rulings issued. Okay, so all appeals have been exhausted. Okay, that's the first part of the test. There are no pending appeals on the legal issue that is under dispute. Then you come up with the second part, and that is that the agency, whether it be city, borough, school district, township, whatever, actually has a copy of the transcript. Because in many cases, the agency will contract with a private transcriptionist and they'll pay an hourly rate. But if they don't need the actual transcript, they won't pay for that. Now, let's say that they have paid for it, okay, and they have it in their possession. Well, then they've met the second part of the test. The transcript is clearly a public record. It's in possession of the agency, so they can provide it in response to a right to know request, and the fee schedule applies. So it's only up to 25 cents a page. Now, let's say that the agency never requested a copy of the transcript. So it's still in the possession of the private transcriptionist. The requester, well, first offhand, the right to know request would be denied by the agency because they don't have the record that's been requested. So the only way that the requester can get it would be to go to the private transcriptionist and pay whatever fee they would charge. And usually it's a couple bucks per page. So you're going to end up paying a lot more money, okay, for these, for the transcript, okay, because the two-part test has not been met. All right, it comes up periodically, and that's what you're dealing with there. And that is covered in Section 707C of the Right to Know law. Okay, so ran a couple minutes over, but I think we covered everything fairly well. Additional resources. Before we sign off here, if you have any further questions, now's a good time to get them in. If you have any questions after we sign off, like I said earlier, feel free to reach out to the office and they will turn it around fairly quick and get you headed in the right direction. But in the meantime, you want to take a look at our website, okay? I've referred to it several times during the session here that I'll just come out and say it. It is the best government website you will ever encounter. Number one, it gets updated 6 days a week with new information, new decisions, new court cases related to the right to know law, related to the Pennsylvania Sunshine Act, which governs open meetings, just government transparency in general. Okay, new information out there. At the same time, there's some very useful guides for citizens, guides for agencies. I mentioned the Arrow guidebook, which hopefully is still there, 78 pages, very useful information for any agency open records officer that can help you get your open records program up and running or fine-tuned or whatever. All of those final determinations, the final determination is the product of an appeal. It's in excess of 30,000 and counting in a searchable database, okay? It's out there for you to find and use in understanding the right to know law. If you have any training requests, again, reach out to us. If you're a real geek about government transparency, you can subscribe to our Twitter feed where every morning at 8 a.m. we will wake you up with all the news that you should be aware of for that day. in the world of government transparency. Again, reach out to our office if you have any further questions, but I'd like to thank you for your participation today. Some good questions. For some of you folks who were kind of off topic, I sense that maybe you want to sit in next time we do basics of the right to know law, or like I said, if you have something specific, reach out to us and we'll get you steered in the right direction through a direct conversation. But again, I want to thank you for your participation today. We'll be back in 2 weeks with another topic. In the meantime, stay safe out there. Oh, one has come up. I had no audio for this. Okay, I put the words to read along. If you can go back and read the entire presentation. Okay, I'm not sure what you're dealing with there, Pamela. Everybody else had audio and they didn't have any problems. I would suggest, maybe the issue is on your end. So have one of your IT staff maybe look at your connection and hopefully they can take care of it. But the audio was working for everybody else. Oh, except Teresa. So she had to adjust the volume on her laptop. Okay, so again, it sounds like any audio issues were local. All right, I'm sorry I can't help you out from this end. I would just suggest that next time, do a test ahead of time and see if you're having any issues. But I'm sorry that, things didn't work out for you today. Okay, folks, I'm going to sign off. Again, we'll see you in 2 weeks, and everybody take care.